received a great question from a doctor who lives here in Florida and had questions about the religious exemption that we are afforded here in the state of Florida and an ability to go to school. So I'm going to read his question, then I'm going to answer from my experience and from what the law states. Can a religious school in Florida refuse to enroll or re-enroll a child who has a valid DH-681? And 2, are you aware of any pediatricians who will continue issuing DH-680 medical delay forms every 6 months on an ongoing basis? What other options are there? Welcome to the Dr. Thornburg Wellness Podcast, where pediatrics meets functional medicine, blending science-backed insight, common sense, and a touch of shamanic wisdom from a father of 8. Hi, I'm Dr. Brian Thornburg. I received a great question from a doctor who lives here in Florida and had questions about the religious exemption that we are afforded here in the state of Florida and an ability to go to school. Apparently, he is having a hard time having his child admitted to a private religious school, and he is asking if there is a way to move around this or if the school is acting legally. So I'm going to read his question, then I'm going to answer from my experience and from what the law states. And again, this applies for Florida. We are in Florida. Each state has a different set of laws, regulations, Court of Appeals, district. So I understand the laws here. The question is coming from a father who is asking a question in the state of Florida. So this has applicability here. I don't know how this transfers or what reciprocity exists with other states. It says, hi, Brian. I'm a doctor in such and such, and I've been following you since well before you became widely known. I'm writing because I could use your advice. My daughter has been only partially vaccinated. We spaced out her vaccines, and she has now aged out of many of them. At one point, my pediatrician told me that the Department of Health was no longer allowing delays beyond 2 months, though I was never able to verify that independently. Since her school requires the standard vaccination form, I decided to proceed with a DH-681, thinking that that would settle the issue, as I do not plan to continue vaccinating her. Instead, the school told me that they would not accept it. This is my note. The DH-681 is the religious exemption form. Back to his letter. I've spent a lot of time trying to understand the legal issue. My understanding is that the DH-681 is the official Florida religious exemption form and is generally accepted by public and private schools. But I've also come across the possibility that a religious school may still refuse it under the 2017 Flynn versus Diocese of St. Augustine case. Our school is religious, so this leaves me in a bind. I do not want to vaccinate her further, but the school may refuse to enroll her. I also saw that Florida SB 1756 proposed a conscience-based exemption, but it appears not to have become law. My 2 questions are, can a religious school in Florida refuse to enroll or re-enroll a child who has a valid DH-681? And 2, are you aware of any pediatricians who will continue issuing DH-680 medical delay forms every 6 months on an ongoing basis? What other options are there? I'd be very grateful for any guidance. Best, and his salutation. I purposely kept his name and family blinded. So this has been an ongoing issue. So here in the Diocese of Venice, where I'm in Naples, Florida, they do not accept religious exemptions. In the Diocese of Miami, they do accept religious exemptions. Apparently, in the Diocese of St. Augustine, they do not accept religious exemptions. The other school here in Collier County that does not accept religious exemptions are the Jewish schools. We have 2 Jewish schools, and neither of them will accept the religious exemption. And for many, many years, I thought that this was illegal because if a school receives their charter to be a school from the state of Florida, then you must follow Florida law. My belief was that since the school had a charter and was accepting students, and they clearly were licensed by the state of Florida, then they had to follow Florida law and accept the religious exemption. However, having enough time around life and medical field and the legal field, I know that there is never a straight answer. Just like in medicine, there's always something outstanding that can always confuse the situation. As my anatomy professor used to say, this is the exception and this is what is beautiful here. I always found that odd because the exceptions were harder to learn because they were unlike everything else. But once you understand everything, the exemption becomes very, very important. And that's where nuance and the edge of the issue resides. So the confounding issue with this 2017 case resides around, and I'm going to read some of the facts from the case. It involved apparently a Catholic family with 8 children, and they had some of their children vaccinated, some were partially vaccinated, and others were not vaccinated. This one child in particular, was able to attend preschool and then was with partial vaccination and with a religious exemption, but then was denied admission into the next class up, first grade, because she was not fully vaccinated and they no longer received the religious exemption. The lower court ruled on the side of the archdiocese, and they applied the doctrine of ecclesiastical abstention. It's also known as the church autonomy doctrine, concluding that adjudicating this dispute would require impermissible secular court intrusion into the diocese's internal religious affairs, faith, discipline, and school governance. And because there needs to be a separation of school and state, the court ruled on the side of the archdiocese. The family did appeal the case to the First District Court of Appeal. The appellate court heard arguments and issued an opinion in 2017. The legal issues from the appellate court was, again, they restated the ecclesiastical abstention doctrine, stating that the civil courts are barred from resolving disputes involving, quote, theological controversy, church discipline, ecclesiastical government, or the conformity of the members of the church to the standard of the morals required of them, end quote. Basically, the state does not have a right to dictate how a church operates on internal doctrine and faith. Another key legal issue was application to schools. The court treated the diocese immunization policy and student admission decision as internal church matters, not purely secular health regulations. Therefore, enforcing the statute would require courts to second-guess the bishop's determination on a matter tied to the school's religious mission. Another key legal issue was the neutral principles versus entanglement. Courts may sometimes resolve church-related disputes using, quote, neutral principles of secular law, end quote, without delving into doctrine. But in this case, however, the dispute could not be resolved without determining or overriding the church's religious tenets and the practices regarding the school's operations and the common good. And the last notable key legal issue was the First Amendment implications. Compelling the diocese to admit a non-immunized student under the statute would effectively allow the state to dictate aspects of church school governance, infringing on the church autonomy. As the opinion noted, it would, quote, send the message that the secular government can, by statute, take away a constitutional freedom, end quote. So here we have, again, 2 issues. We have that a state provides a charter to a school to exist, and then the school has to be licensed to be in operation. And in order to be in compliance with your charter, you have to follow Florida state law. And here we have a case, at least in the First District Court in the state of Florida, that the secular government, through the courts, cannot infringe upon issues of governance as related to matters of faith. And so unless this is going to be adjudicated or go to trial in each district, this is kind of the guiding example for the state of Florida, since the other districts have not issued an opinion on this matter. To answer its first question, can a religious school in Florida refuse to enroll or re-enroll a child who has a valid DH-681 or the religious exemption form? And apparently in the first district they can, as we don't have an opinion in the other districts, then the question remains unanswered, and it would require an adjudication or a court case to find out how that district would rule. However, seems to be somewhat of a following of a standard doctrine, and so there would be a look out to the other districts, especially those in the same area, to see if there's already been a case that has similarly addressed this issue. So this might fall along the lines that a secular government cannot infringe upon the doctrinal authority and governance of a religious school. However, this does not answer the question about a private non-religious school. Apparently, a private non-religious school must follow their charter, which means that they must follow all the laws of that state. And so, unfortunately, I believe that this is true, that a religious school in Florida can refuse to enroll or re-enroll a child who has a valid religious exemption. His second question, are you aware of any pediatricians who will continue issuing the DH-680 medical delay forms every 6 months on an ongoing basis? What other options are there? So what he's asking here on the second question is, we have what is called, or what used to be called, the blue form. It is the vaccination form that we have to it's an official vaccination form that we provide to the schools to show that a child is up to date. This form can receive a temporary exemption up to 6 months because sometimes a child has a medical intervention that precludes them from receiving a vaccine. And of course, they shouldn't be removed from school because they are undergoing medical treatment. And so there is a 6-month allowable delay that can be moved down every 6 months to further delay the administration of another vaccine. In my county, all of the religious schools will allow a child to be enrolled if they receive one vaccine every 6 months, because that is in alignment with the doctrine that a child should be vaccinated. And so they don't have a problem with that slower approach. And so I will write the 6-month delays on the remainder of the vaccine schedule, as long as they're coming in every 6 months and receiving a vaccine. However, this physician, stated that he was no longer going to administer any vaccines to his child, in which case he would just ask for a perpetual annuity of the DH-680, the school vaccine form, with a continual delay. And of course, since this child will not receive a vaccine every 6 months, that would be difficult to find a pediatrician to write for that form. The last question he had is, what other options are there? The third vaccine exemption option is a medical exemption. For a medical exemption, there needs to be a reason that the child cannot receive the vaccine. And there are some strict definitions as to what conditions are needed in order to qualify for a medical exemption. This would tend to be an anaphylactic reaction or some other immunological issue, or possibly the child on ongoing chemotherapy, in which case they could receive a medical exemption. There needs to be something that is clearly would put the child's life in immediate danger. And there are some physicians around the state who will write medical exemptions for medical reasons other than those that would cause an immediate harm to the child, such as MTHFR and an eczema concern. The reason they can justify that is that the American Academy of Pediatrics in the 1970s wrote as a position that a child who has eczema should never receive vaccines. I'll say that again, because that is a very different position they have now. Their understanding of the immune issues and complications of vaccines in children with eczema or atopy would preclude them from receiving the vaccine. Some of these older doctors will write a medical exemption for conditions other than acute immediate concerns to the child. And these concerns can be MTHFR or allergies, or for other reasons. You'd have to find that, and then you could submit. And some of the families in my practice have found physicians to write that, and then they will submit that as a medical exemption to the school to allow their children to go to a religious private school. And again, the secular private schools must receive the religious exemption. So I do appreciate the question, and I doubly appreciate the questions coming from a physician, and the physician is taking a very hard stance, again, giving additional vaccines to his child. I can say that this physician is very well recognized in the medical community and is a chief at a major medical center in his academic area, in his subspecialty area. So this vaccine issue is an ongoing issue for public debate, and I do appreciate this question, which is why I made this video, because I think it needed to be clarified about how to obtain a religious exemption, when they will be considered valid, and when they will be accepted by the school. It's important to understand that there is another option called conscious objection or philosophical exemption. The state of Florida does not offer this. I believe there's 7 to 9 states in the United States that will receive the philosophical exemption. And then last, every state will receive a medical exemption. There are strict definitions for writing a medical exemption for a patient. The state of California has a board or a regulatory body that reviews all of the medical exemptions written in that state to make sure that they only follow the very strict definition of immediate concerns to that child for receiving a vaccine. And then, again, older physicians who remember the American Academy of Pediatrics position 50 years ago that if child with eczema should not receive vaccines at all and should qualify for a medical exemption. So you can find physicians who will write medical exemptions. But that does raise the question, why did the American Academy of Pediatrics make that change in position? And why can't I find a paper on that position and justifying the change? So again, there's lots of unanswered questions. And recall, Section 13.1 of every vaccine in their vaccine insert states that this product has not been tested for carcinogenic, mutagenic, or impairment or fertilities. Half of the vaccines contain adjuvants. Adjuvants activate the Th2 side of our immune system. The Th2 side of our immune system, if left unchecked, if left unregulated by the other side of the immune system, the Th1 system, that side can lead to cancer, yet the vaccine insert states that we are not going to test for this concern. And also, we know that there is not a single vaccine that has been tested against an inert placebo. They have been tested against active placebos, which is quite different. An inert placebo is a placebo that will affect no change on the person receiving it. It is a true control. It is a saline dose. It is something that will not impart a physiological, biological, metabolic change in the person. All of the vaccines have been tested against an active placebo, which is something that will enact a change on the body at some measurable level. And so these would include an antibiotic, another vaccine, or a toxin. So to state that a vaccine has been tested against placebos is obfuscating the issue. They have not been tested against inert placebos. They've only been tested against active placebos. And again, we have no long-term safety or effectiveness trials. And just to highlight that point really quickly, the hepatitis B loses effectiveness, essentially has a shelf life after 10 to 15 years for the majority of its recipients. And if we're giving the hepatitis B at birth and completing the series before 1 year old, then that means by the time they're a teenager, they no longer have active protection against hepatitis B. And what are teenagers more likely to do? Have unprotected sex. And you would think that you should administer a vaccine at a point in time when the majority of them would still have protection against the vaccine that protects against sexually transmitted diseases. So there's a lot of glaring gaps in vaccine science, in the propaganda, and the mainstream understanding of how safe and effective vaccines are. That's why I highlighted this letter from this doctor, because we need to get the message out there so we can get the right research in there. Because if we can get the right research in there showing what the real effects of the vaccines are, then I will support whatever that data shows. But right now, all I can say is you are in a blind shooting gallery and your child is the one that's being moved across the stage to be shot at. And that is not right. Thanks for watching. Thank you for joining us on the Dr. Thornburg Wellness Podcast. Come for the science and common sense. Stay because it works.